Oh, cool.
We're live.
Welcome back to House Healthcare, everyone. It is still Thursday, and we are switching our schedule around a little bit because the Senate is still on the floor. So we're going to do a committee discussion on S89, which we talked about earlier today. So this is the bill that Judiciary has to create a forensic facility, 9 beds in the Vermont Psychiatric Care Hospital. So we're going to have a little bit of a discussion, go over some proposals we might add to Judiciary, and then open up for a broader conversation. We will have to stop at 3 or so because it's going to switch to 47, but we are going to come back to this. So, all right.
You pretty much answered just now. I just want to make sure that this bill creates the facility, doesn't
Yes.
create the facility.
This creates the facility.
It does. So
Yes.
it puts everything into place that causes this facility to be created.
Yes.
Okay, that's my overarching question. All right.
Okay.
Yep.
Any other questions about or concerns? Questions, concerns?
Well, the other concern is the Medicaid stuff, and I'd like to understand that better.
Okay. So the Medicaid, I'll try and do this justice. So IMD is a federal designation. And we've had a waiver for years that allowed us to have more than 16 beds. So Vermont Care Partners is what, 24 beds? And no, right, sorry, yes. So is 24. And there's other IMDs around the state. And so we are now in a phase down. So the federal government has come to us, and Daisy, you're going to correct me if I get any of this wrong. Federal government has come to us and said, okay, we're done. We're only paying for a facility that's 16 beds. So when I say pay, Medicaid matching dollars. Or the length of stay is less than 60 days. So there's two things there. And so we've known this. And I think the phase down now takes us down to 2027, when if we have a facility that is more than 16 beds, we will no longer receive Medicaid reimbursements.
For the individuals that are in there?
Yes. That is how so Medicaid patients that are in getting treatment receive matched dollars, right? So at the end of 2027, if the facility is greater than 16 beds and we don't get a new waiver or some special thing from the federal government,
Assuming that doesn't happen,
we will lose the federal matching. And so there actually is a report that we received and will receive. I think it's a yearly thing, maybe not, and it talks about what's going to happen. And it's flagged for us, for me anyway, for us to review next year, because there really is no solution yet what we're going to do other than have to either keep the length of stay under 60 days or use general fund dollars. Or close down.
So there's only 2 IMDs. Brett over here shoots the other one. It's 16 beds or more, and there is an age restriction, remember? So it's, for individual 60 days or less. And then there's the age restriction, which is 24 years or less, or 60 years or older. And because it's 16 beds or more, taking the 9 beds offline.
right, I
is
see
actually making it not an IMD.
I see why this is important.
But it's the same
mentioned in the bill.
Right, but at the same time, so if the 9 beds, if we convert it to a forensic facility, so as Daisy said, then we would be fine. And on the other 16 beds, we would continue getting the Medicaid match when it's appropriate. Except for, because they're connected, the federal government could say, no, we don't recognize that. We still consider it one.
Game in the system.
Or, whatever their criteria is. And that was Topper's point earlier.
Right.
So if that happens, the administration will have to come back to the legislative body next year and say, we need general fund dollars to keep moving forward.
Can't they get an advance ruling on this? Can't we?
So they have testified that they're in discussions with them, but there is no, formal yes or no yet. Does that help? It's like,
Can we put this off a year then?
That was 27, though. I thought it was 25. I don't know why.
no, it's 27.
So I sent that report around last week to everybody, the 2023 report on IMDs in Vermont was sent by AHS to us.
And it's in the
January.
legislative report section 2.
What's
Your email
IMD?
from last week.
What's IMD?
Institutes of Medical Diseases. And the phase out is actually, it's longer. I think we asked for an extension. I think it's 2028 or 9.
9. I'm looking at it
Did we
right
get
now.
it? Did we get
I'm
the
looking at it
extension?
right
Okay.
now.
Yes.
Yeah,
Okay, so 29. So we have some time.
yeah, what Daisy sent is right there, and the executive summary is really short. It's only 3 paragraphs.
Did you pronounce IMD?
But I would.
Take the 9 beds out, make it a forensic facility if we get.
Yes, and personally, like, I would just like to say, I strongly believe that, our Medicaid experts in the state are just that, they're experts. And I don't think that they would be risking
Right.
the care of these individuals
Yeah.
or, their
Their credibility.
Everything.
Yeah.
right? And they are in contact with CMS. They're aware of this and they know what's on the line.
Worst comes to worst, maybe I'll get another waiver anyway if they decide against this.
I mean, we never, right, so we don't know. So I think we have to go
Right,
forward
okay.
with what we
Right.
understand to be today. We also have to remember that this, I think the effective date on this, the rulemaking starts, but if I remember correctly, it's like 2024, right? So,
Now, what about the people in the 9 beds, in the forensic facility? Does Medicaid cover them at all?
no, because they're in the criminal justice system. Yeah, and so they don't cover them today either.
So then we pay for general fund.
Yeah,
Right,
yep. Which we're doing now anyway.
right. Okay, so some of the things we talked about earlier, I'm going to take each one and then we can have a discussion on each one. So the first one was in the very beginning of the bill. So I'm just pulling up the 3.1 draft that Katie had walked through. It talks about the Human Services Community Safety Panel. And on page 2, row 11, it says the panel shall have the technical, legal, fiscal, and administrative support. And so I think we want to add clinical in there.
She's in that email.
Yes, I know. I'm just bringing everyone around to where we are. So
What page, Lori?
So on page 2, it would go in row 20, row 11 or 12. And you do have an email from me that has a list from Katie of these changes. So, everyone seems good with that? Yep. Yeah. Oh, I said yeah. Oh, okay, good. Okay, and then the next one was section 3. Section 3, which is on page 4, starting, go down to 4. Starting on row 16. So remember, this is where they're looking at criteria. In row 11, they look at clinical factors. And then starting in row 16, they start looking at dangerousness factors.
What page? I'm sorry.
4.
Okay, I'm on the wrong page.
Is everyone there?
Yeah.
Okay. And we had some discussion even with Karen Barber from DMH that, maybe dangerousness is not the right word. They seem to be attempting to get to, I think, the same issue that Alyssa and Art wanted was around public safety as well. And so Katie is recommending that we just change dangerousness to public safety factors. We did check in with, real quick, the chair of judiciary who asked, well, using public safety, does that mean anything in regards to other statutes? And Katie felt fine that it is just public safety factors. But that's, we don't have to use that language, Brian.
Yeah, I would recommend safety factors. Because then it's safety to all, not just the public, but also to the individuals, interpersonal safety. But I'm fine with public safety too, but I think we could just say safety factors.
Okay, I would, everyone think?
Yeah, I would prefer it to say public safety because we're not talking about, well, I'm not thinking about the safety of the individual, I'm thinking about safety of the community.
Yeah.
As in distinction.
Yes.
Yeah, except that then the following bullet point says
Right.
harm to, it says bodily injury on another, but then it says attempted suicide or serious self-injury, which if happened in a contained location might not threaten public safety in an apparent way. Although I would argue that taking care of people's needs when they're struggling is what's best for public safety too. Like that, when we neglect people's needs, that leads to violence, that leads to people, so, but I don't want to get down another path. I guess the point is I feel like safety covers this in a broader sense than,
I agree, because we're talking, that would cover everything.
Yeah.
Just safety covers public safety as well as safety of the individual.
staff safety.
That's consistent with,
If she's raising her
I
hand.
know, hold on, the only one raising my hand. Go ahead, Daisy, keep going, go ahead.
it's consistent with the one before, which is just called clinical factors. So safety factors is also consistent with the terminology.
Okay, Alyssa?
Okay, so my point is, if we start changing it to safety or community safety or self-safety, whatever safety, and we're gonna have to start parsing out things and changing them. And really, in the end, what's wrong with dangerousness?
Because it puts the focus on the impact of someone's behavior.
But that's what this section is saying that they need to take into account is that very thing. I mean, that's why they have all these, you need to look at this and this and this and this. I mean, that's what this whole section is. And then, I mean, it gets down to B, which is whether the person has threatened to inflict serious on another person. I'm just saying that this one little section is they're supposed to look at the dangerousness of this person.
So let's
What's
start,
wrong with the language?
let's start with real simple question. Who doesn't want to use the word dangerousness?
Who doesn't want to use it?
Yeah.
I don't know.
Who's neutral?
I know I said it, but I didn't say it here. I thought it was in a different place, but anyway.
Who wants to use dangerousness?
Doesn't care.
I don't
Who
care.
does? Okay, so there's a lot of, I know,
Yeah.
I figured you. Yeah. Okay, so it's a neutral or don't want to use it versus one who does. So we're gonna not use dangerousness. So now let's go back to public safety.
Yeah, so I the reason I proposed safety is it's broader, and then I just wanted to also explain why I think safety, for me, is a preferred term over dangerousness. And so in the training I have as a social worker, there's a theory called the strengths perspective that I studied. And in the strengths perspective, it's about trying to focus on the strengths and assets and positivity when working with people and not on their illness, their problems or their challenges, because we live in a society that has been built with a negative lens where people become stigmatized because of that. And harm is caused when we focus too much on someone's suffering or illness and not enough on their resiliency or their recovery. So in the strengths perspective, we don't ignore the suffering of people, but we try to put more attention on their strengths, because by doing so, it empowers people to heal. And so that's why I think safety is more of a strengths perspective use of language to have in statute, because it's saying, like, when you say safety factors, we're acknowledging that there's risk, but we're thinking of it more like, how do we promote safety versus like, how do we stop dangerousness, and that's my angle, and it's no judgment of others. I'm just explaining why I feel so strongly about the term.
Melanie?
The only thing is that everything is listed as a dangerous, do you see that underneath it? Including, I hear what you're saying and I support it, I just don't know how it's Does it still work? I guess is my question with all.
If we use
A-
safety,
With A, B, C, D. That's listed under here, you said it wasn't.
I mean, it ends with any other factors that the Human Services Community Safety Panel determines to be relevant to the assessment of risk. So that ties it all together back to safety.
I see no reason that safety doesn't fit there.
Okay, I just was asking because of the way that it was written.
Leslie?
I actually think that safety works because it says attempted to inflict serious bodily injury on another or suicide or self-injury. So it's really looking at the
Yes.
outward and
Yes, that's what I
inward.
was getting
And
at.
that's what I want to be able to do. So I'm okay with safety as I'm reading what comes next.
You see my point?
Yes, I see your point. So that's what I'm thinking.
Okay, anyone who hasn't spoken yet, who has any?
Listen, can I just remind everybody that we're talking about forensic population that is entering this population because of,
An accusation.
yes, because of, they're coming in through the criminal justice system. They're not.
They're innocent until proven guilty.
Yes.
Okay. Who wants to, before I do a little, this straw poll is not binding, I just wanna,
Yeah.
that's where we're going
It's a
here.
vibe check.
It's a vibe check, I like that. Before I do a vibe check, does anyone have any comments? Safety versus public safety.
I have one comment, which is that we're gonna spend an hour discussing this one word and then judiciary is gonna just do what they want. That's my comment.
All right, who's comfortable with using safety? Who's comfortable with public safety? Okay. So safety, one, on that one, but we'll come back to it. Change to safety.
Say private safety. Just kidding.
No, we're not going there.
I thought you were going to say private.
All right. Then she did not change, but we also had this discussion in that same section, right? So row 19 on that same page. An act that would constitute sexual, lewd, and lascivious conduct with a child. I think we just want to get rid of with a child. right?
Yeah.
So you just take it out.
Yeah.
Is everyone okay with that?
Yeah.
And this might seem like a weird thing to ask, but like, I'm just thinking this through before I say it, it comes out wrong, because I want to start by saying that sexual violence is very serious,
Right.
but I'm just trying to think, like, it says if there's reasonable probability that the conduct will be repeated if admission is not ordered. So I wanted to start with that because if that's the case, then yes, any sexual or lewd or lascivious conduct with anyone, if it's that bad that they need to be put in here, then they should. You know what I mean? Regardless of who it's towards. But I just wanted to be clear because I think, like, I wouldn't want someone being put in a forensic facility just for being inappropriate if they did. I don't want to minimize sexual violence, but like, people might say the wrong thing or get accused of saying something, and I wouldn't want them like, but this is saying, like, if there's probability the conduct, so someone would have to clearly be inappropriate repeatedly to be put in a forensic facility. And I think if someone's engaging in like inappropriate sexual behavior towards anyone repeatedly, to the point that they're getting involved in the justice system, and if it's determined they need to go here, they should. So I just wanted to talk through that a little before I agreed to it, because it sounds like you really would have to, and I'm trying to use words that aren't like puns here, like, you know, it would have to like be serious enough that they'd be able to have to justify the placement. I said that in a way that didn't come out as a joke, because I'm trying to not make it funny. It's not.
So all of that to say, I think you're agree with removing with the child, right? Brian, before you look at that note, you're okay with removing with the child?
I am,
Okay.
yeah, I think so. But, and yes, although I don't think it's minimizing the extra harm that happens to children or
Right.
elders or people with disability, like developmental disabilities, when they're vulnerable and someone takes advantage of them. But there are all kinds of laws out there to protect people that would be wrapped into this and covered by the general term. In other words, by removing with a child doesn't mean that we're not Yeah, exactly. It means we're just expanding it to make sure it could be anyone.
And I feel like judiciary could help us.
Yeah.
And
We-
You're gonna have some input.
Right.
Yeah.
well, they're also saying that, and there's reasonable probability that that conduct will be
Right,
continued,
right,
so.
right.
I almost think I'd rather leave it like it is and let them make that call.
Well, what we can do is we can make the recommendation and they will, like, because they know the law around
Right.
lewd and lascivious behavior, so we'll definitely preference
Yeah.
that. with that. Okay. Then, section 23, Maury had a suggestion for, I'm gonna let you talk about it, Maury.
Section 23, you'll find that on
What page?
33, it actually starts on 32, but that's just the heading, so go on to page 33. Annually, on or before January 15th, blah, 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 shall submit a report to the committees containing, and then there's, in the bill, there's 4 items there. We're adding, my recommendation is to add a 5th. And Katie captured most of what I was getting at. Katie added, and data summarizing the number of days before discharge from a forensic facility that notice was provided, the method of notification, and which prosecuting office was notified. I'm not clear on her first sentence, data summarizing the number of days. That sounds like how many days between the notification and the discharge. What I also would like is the numbers of notification, the numbers of times there was a notification. And if we could get at the numbers of times there wasn't a notification and there was a discharge.
Okay, so I'm gonna have you work, so Katie will be here eventually, and we can, that's to hold that.
Okay.
For Katie. So I'm also gonna say it's 3, so pretty soon we're gonna switch to 47, and Senator Vyhoski just texted she's on her way up. So I think what I'm gonna do, if everyone's okay with this, is have Senator Vyhoski tell us why she sponsored S65, which is the EpiPen language. I don't want to spend a lot of time on it. We just want to hear from her. We're going to switch then to 47, and we're going to come back to 89. I'm sorry for doing this. It's just kind of the way things happen at the end of the session. So, all right, so we good? Come on up. Thank you.
Sorry, we're still on the floor, but it's charters. I can.
So you're in a hurry and we are too. But so we want to understand why you sponsored S65, and if you can introduce yourself.
Yes, Senator Tanya Vyhoski. I represent Chittenden Central. Thanks for having me. I sponsored H65 because it's my view that life-saving medication should not be unattainable for people due to cost. And it is my understanding that presently, all of the insurance companies that we regulate keep that at a tier 1 medication that maybe $10 or $20 or $30, which over the course of a year could be cost prohibitive for some. However, there is nothing in legislation that prevents that medication from moving out of a tier 1 to a tier 2 or a tier 3. In 2017, I went to pick up epinephrine, and the medication that cost me $15 the month before was $586 because the company that makes the medication had raised the price, and my insurance company, which is Blue Cross Blue Shield of Vermont, moved the medication from being a tier 1 medication to a tier 3 medication, and I was now responsible for 50% of the cost of the medication. So while this bill may presently only impact a handful of people with a handful of money, it will protect them should it happen again, that those medications become astronomically expensive and are moved into a cost prohibitive category for people. And to be clear, epinephrine is a life-saving medication. So that's why I sponsored H65.
Okay. Any questions?
You mean that's
That's what I mean.
If we could change it to indicate that insurances would have to have at least one drug covered. one brand or generic covered at no cost share, would that be something that you would, I guess, would you be pleased with that?
I mean, it would certainly be better than nothing, although as someone who has a rare genetic condition that causes me to sometimes react to one generic but not another version, I do think that it would be problematic if you have someone who can't use that particular generic. So my preference would certainly be that we just say that epinephrine or generic epinephrine if there's multiple kinds of generics.
And we have to be sure that we specify auto injector, not like having to draw it from.
Yes, and the bill does, I believe, clarify that. And we heard from, this bill was actually taken up by Senate Finance, and they heard from the health insurance companies that they don't actually think it will have that much of an impact, and they were not opposed to the bill.
Yeah, we heard from them as well.
So part of our conversation was thinking about other emergency drugs, glucagon, albuterol, So wondering what you thought about sort of expanding it to, and I guess we can do that today, obviously, but thinking about it from a broader perspective.
I mean, that is certainly part of my putting this forward as well, is a precedent of looking at whether or not we feel it's acceptable for life-saving medication to bankrupt people. And so, yes, I would very much support looking at a broader scope of medications that save people's lives. I don't think it's a secret to anyone that I just support universal health care, where this wouldn't even be a discussion we'd be having.
Any other questions?
We can talk about that more now.
No.
And I have to go back to the floor and vote on Fairfax Fire District.
Thank you very much. We appreciate your time.
Yes, thank you.
Okay. Claire, Karen here? They're on, okay, can you, yeah, you can let them in. Okay, so there is, hi Karen, welcome back, and Jack. There is new language on our committee page. So this is one of those situations where
47.
we're on 47, sorry, yes, we're on S47. On our committee page, there's a 3.2 draft under Katie's name. Again, this is a situation where unfortunately, due to scheduling, we don't have Katie before the witnesses. So I'm going to say about the language, this is being put forward by Department of Mental Health after hearing various testimony amongst the two committees, so our committee and judiciary. And I'm going to let them explain why, and then we'll hear from Jack and Dylan, who's officially going to testify other than just having them on the side of the room like we have all week. And then we will have Katie walk us through the language. But this is actually a pretty substantial change in what we've been discussing.
This is 2.1.
This is 3.2.
3.2.
So in this new language, we are not changing the status quo on temporary custody or the warrant process. We are adding language about personally observing something, and then we are adding a study. So I'm going to leave it, or report, I should say. We'll get into the details of the language. I'm going to turn it over to Karen to start from Department of Mental Health since they put this forward. So thank you and welcome back, Karen.
Thank you. Good afternoon, Karen Barber, General Counsel for DMH. Thank you for having us. So we heard, the testimony both in this committee and in House Judiciary, and there were clearly a lot of concerns raised by Will DeWitt and Jack McCullough. And the department kind of regrouped and went back and kind of really took stock of the concerns and kind of the process as is, and talked with Vermont Care Partners about some of the concerns that were raised. And I think we both agreed that what we really needed was more time to come up with a more thoughtful approach, that S47 as written really probably wasn't the best path forward. But clearly there was also maybe some immediate steps that needed to be taken to kind of address some of the concerns that were raised. So we did work with BCP and also with Jack to come up with language that was agreeable to everyone. And basically what we agreed to do was to kind of add some clarity language now around what we mean by personal observation. have that expire in a year unless the legislature takes further action, and require that DMH kind of study the issue in consultation with various stakeholders such as Vermont Care Partners, Jack McCullough, and those with lived experience to really think about what makes sense in terms of the Warren statute and what, if any, changes do we need to make. So we just feel like, given you're at the end of session and there's some real things that clearly need to be worked through, we don't have time to be real thoughtful about it. And we want to make sure before we propose changes, we've had a chance to think about them. Happy to answer questions.
So, yeah, and I just have one. So how do you see this being different from the group that came together over the summer that came forward with the recommendations we started with?
So there was a group that met. I think both Jack and I were a part of that group with some others. We did not necessarily support the language that made it through the Senate. We also, I think, based on some of the testimony, felt like maybe we didn't have the best grasp on what exactly was happening in the field and what may be of concern to folks. So we wanted to really take a step back. I think now that we have a better idea of what maybe some of the issues are, we can really actually have more in-depth conversations. I think there is maybe some miscommunication over the summer in terms of what people were trying to solve and what we thought we were solving for.
So who is going to do it again this summer, and how is the outcome going to be any different?
Well, it's going to be DMH led. I think one of the things before was it was kind of more of an informal group, one that DMH didn't really have a key part of. And as I said, we didn't necessarily, we didn't put the language forward this session, nor did we ever testify in the Senate about it. This is the first time we've kind of had a chance to really kind of dive into it. So I think that will be different. I also think that there's clearly some concerns that have been raised by Jack and Wilda that weren't things we talked about in the summer study group. And so those are things I think that go to the heart of the issue and that we'll have a chance to really more formally discuss.
Any other questions for Art?
I have a question for you, Lori, more than our guests here. In looking at this, why is it hearing on one, then repealed on the next?
Oh, that's going to be a question for Katie.
Okay.
Let's hold that for her. There's
right.
a reason. Yeah.
Well, then what are we doing here?
So we would be, and maybe Karen, can you answer that? Since we don't have Katie with us.
Yeah, so I think what we feel like is that there is maybe the statute language maybe is a little is maybe unclear to some. And so what we really want to do again is be more thoughtful and have time to do that. But we also, based on some testimony we heard, feel like we need to really clarify right now for the next year what we're going to do. And I think, you guys, you could do nothing and we could leave statute the way it is. I think what we were trying to do is kind of get a little bit of a compromise that would meet some of the concerns of VCP and also some of the concerns of legal aid as we move forward.
I also think A and B are the same language.
They are.
So that definitely is a question for Katie. I don't know if it's an issue with the version or if we're missing something.
Yeah. That's what I'm saying.
Right. Go ahead, Karen.
I was going to say, sorry. So because I think what we talked about was that we put this language in effect for a year that does kind of change the statute, it would repeal in a year unless you took further action. So that it's repealing it in a year.
Okay.
Okay, got it.
Okay.
Thank you.
I see. Blind man. Okay.
Leslie?
Thank you, Karen. I mean, you talked about clarifying, and could you list sort of for what's being clarified? And that's what's confusing me, and I haven't been able to hold them side by side. So I'm not sure what we're clarifying.
So really, we're taking out
Everything.
everything, all of the changes 47 was making, and we're going back to the way the statute is written. But I think also we heard some testimony that maybe there's different interpretations as to how to read the statute. So what we're trying to do is provide real clarity about what's okay and what meets the threshold for constitutionality and due process in terms of personal observation. During this year, will we have time to really kind of thoughtfully think about it? Because I think what we all heard is there's clearly some disagreement about that. And so our goal is to just seek to clarify that, add some parameters around it for a year, and then come back after we've had a chance to really sit down as a group and talk about it some more.
So this language, so for now, completely not pay attention to the other versions of this. And this language that's highlighted on page 1 in yellow basically deals directly with the personal observation, which, right, we've had a lot of discussion around that. And this is saying the situation has to be observed by the mental health professional or the law enforcement officer personally, or it shall be supported by a statement of facts under penalty of perjury by a person who personally observed the facts when the mental health professional or the law enforcement professional didn't see it.
So the issue of transport by a mental health professional is gone.
It's gone. Where everything is staying the same. They can have a formal group that looks at and reports back to us. But there are real concerns about who's personally observing whatever the situation is that then leads to the whole current process of getting a warrant. And so DMH is putting forward, and it's our decision, right? DMH is putting forward that we clarify the personally observable piece while everything else stays status quo, and then we add the report at the end. So we're going to hear from others. Any other questions for Karen at the moment? All right, thank you, Karen.
Yes, of course.
So you gave Jack this first?
Yes.
Okay. Jack, hi, welcome back. So thanks for coming on short notice.
Thank you. Thank you for the opportunity to be here again. I'm not muted. Good.
Can you introduce yourself for the record?
Yes, Jack McCullough, Director of the Mental Health Law Project at Vermont Legal Aid. And I want to start out by expressing my great appreciation for the work that Karen Barber has done during the last couple of days to really try to get this to a constructive and workable resolution. And I think it's been very, very helpful. I do think that the language that has been drafted to be regarding personal observation. I'm not sure if it's precisely the language that I drafted, but it's certainly language that works for us, and so we definitely appreciate that. I hadn't really until Karen explained it just a minute ago. I hadn't really figured out that the reason that we have these two sections, section 1 and section 2, is that section 2 is essentially a sunset, a one-year sunset of the language we put in section 1, and I'm not sure that I like that, because I think that we need to get to a language that very clearly protects people from having warrants issued and being taken into custody without verified personal observation. And so setting us up with the default being that we would go back to where we were before is problematic to me. And then the third point is that in the language that I had proposed before, it included the subsection E of 7505 that put a 72-hour time limit on the effectiveness of the warrant. And given that, as far as I can tell, every player on every side of this debate is accepting of that proposal, I don't know why we don't just do that now too.
Okay, so I just want to clarify your point. So you're fine with the language in section A. You'd like us to make that permanent, not repeal it, and go back to the language on the 72 hours.
Yes.
Okay. Art?
Happy to answer any other questions.
Great, thanks.
Yes, Jack. If we don't make it to 72 hours, what is it today? What is that time today? Unending? Is that what it is? I thought I heard that.
If we don't, as of now, there's nothing in the statute that limits how long a warrant.
Okay.
is.
Okay. Gotcha. Thank you.
Any other questions for Jack? Leslie?
Well, maybe this isn't for Jack, but you can help me. I'm not seeing the sunset piece, so can you help me?
We're going to have Katie explain that to
Yeah,
us.
we gotta figure that out.
Any other questions for Jack? All right, thank you, Jack.
Thank you.
Dylan, do you want to join us? Sure. Hi, thanks for being back. You need to introduce yourself.
Ellen Burns, Mental Health Services Director of Vermont Care Partners. I'm going to comment on the kind of new language that Karen just talked about, kind of explain our position on that, and then speak about the kind of different versions, because I think there was a little miscommunication there.
Okay.
So, as you know, we brought this forward even a year ago because we were looking, QMHPs are doing this intense work in the field, crisis situations, first responder situations. We were looking to make it flow better between providers in the field and give people access to care sooner. And that was the spirit of the work group and what we were trying to achieve. So the clarity around temporary custody, who can take a person to temporary custody, the clarity around who a judge can order to transport, those were pieces in the version up until today that we felt like was going to really help get people to care sooner. Our position from the beginning around the personal observation and the witness affidavit piece is that we felt like what was happening in the field was working, and we did have concerns about like risk and safety if an affidavit was required, and just about getting people like the time delays. So recognizing though the kind of context and the situation that Karen talked to, we did help provide input, and it's not the outcome that we wanted in terms of that section of the language, but we were okay with that and can go with that. With the study committee, I think will be really important to really examine. I don't think we've been able to have an in-depth conversation yet around like what are the impacts of requiring an affidavit? What's the impacts for family members, for the people who are served, for screeners? So we think that process will be important, and to like have a thorough engagement with the department and all stakeholders on that. So I came in today thinking that the additional, that wasn't keeping S47 the same, but adding that language, but in fact, the original changes were also still going to be in the bill, and also that the 72-hour piece might be in. So I, apologize, Karen, I wish I could look at you, Karen.
We're all still friends at the end of the day.
But that's, I think it's a function of the end of the session. We're all scrambling in the last couple of hours. And so I guess I would say we did do work. We did talk among stakeholders. People were there, and we came up with some language that so far I haven't heard objections to that's elsewhere in the bill. And so I think our position would be to support that language staying in the bill, recognizing that there's going to be this further look at it.
Including the 72 hours.
Sure, yeah. The concept of the expiration makes sense to us.
And how do you feel about the repealing versus don't repeal?
I guess I think, I can't answer that.
Okay.
Think it through better.
Okay. Leslie, did you have a question? I thought I saw you raise your hand. Daisy.
I'm not exactly clear on what is not in this version I'm looking at.
Yeah.
That should be to help facilitate providers doing the work that they need to be doing right now.
So I saw earlier when I was looking that there were two versions up today, one being 2.1 and one being 3.2.
I'm looking at 3.2 because I think that's the most recent version.
So that's the most recent version.
That's right.
So the changes I'm referencing are the changes that are articulated in 2.1.
Right. So remember we had the language around who could take them into temporary custody, which was a law enforcement officer, right? Clarifying it wasn't the mental health qualified professional. There was that piece. And then there was the piece about how long that they could allow the warrant to be, this is where Jack clarified for me.
72 hours.
Yes, the 72 hours. So those are the two that are now not in this draft.
I don't remember that piece ever being in any version of the bill.
You know what? It wasn't. We talked about it. There was no actual language. Correct.
For 5 days. I remember we talked about something.
So it's one of those ones where, remember, it's endless. So someone could come back and, 30 days later, if they haven't been through the process and the warrant is still sitting out there, it would be a problem. So again, this is language that DMH is putting before us. It's now our decision, once we hear from everyone, how we want to move forward. Mari?
I think it would be helpful, I'm looking at 2.1 as well. It would be helpful if you could provide us in writing the parts of 2.1 that you would like to have back.
Sure.
I'd be happy to.
Thank you.
So let's remember, again, I apologized in the beginning, we don't have Katie. So all of the questions about what's in, what's out, Katie will be coming to help us work through that. That's fine, that's fine, I
I want to
understand
hear
that.
what your
Yes.
preference is.
Yes, that's fine, and Katie will help us work through that as well. Leslie said she wanted a side by side, Katie will walk us through that. So I'm gonna go with Karen and then Tyler.
Me, Karen?
Yes.
Yes, okay, sorry. Thank you. So
Sorry. Go ahead.
I just wanted to clarify that maybe there was a misunderstanding, and if so, that's on my fault. I wasn't trying to put anything forward that there wasn't complete agreement on, and I thought I did hear some disagreement by Wilda, maybe Jack on something, as I couldn't remember, so I really just cut it back bare bones. If there is agreement on other things, DMH is open to that. I was really just trying to do whatever I needed to do to get consensus, to put something forward that worked for folks, and that was my goal. So if there are places where there is consensus, I'm okay with that, but I just wasn't sure if there was. And so that's why when Katie and I talked, I stripped everything out. Just to clarify.
So based on that, Karen, really where you're coming from is you're willing to add the personal observation language that there wasn't agreement on. You're willing to put that forward. DMH would like it just for a year, and we're going to add the report.
Yeah, and the year was really because what I heard from BCP is they felt really strongly that there were some things that weren't working in the field, and we wanted to honor that and hear that. And so it felt like maybe that gave them a path forward to propose new changes. I also hear what Jack's saying. I don't know that the department feels strongly either way on that one. Again, my goal was just in a day to try to build some small level of consensus and put something forward that worked for people. So I'm open to that changing if that's whatever the consensus is.
Okay.
Sorry, I thought I did a better job at.
No, you are perfectly fine, Karen. You are perfectly fine. I think what I would like to suggest is that Karen and Jack and Dylan meet and you provide language to us on Tuesday. Can we suggest that?
That's great.
Okay, and I'm going to be really clear. So I'm going to put on the schedule Tuesday. We're going to have language with a possible vote because we need to get this out if we want it to cross this year.
Yeah.
If you all come together and say, you know what, we just want the report, or, but I would really like all three of you to, as much as I can't force you to be in agreement, but come forward with language and be clear about what you do or don't support. Can that work? Everyone seems to be shaking their head. Yes. Okay. Topper has a question.
Yeah, I just want to make sure that something happens. A person can be transported.
Yes.
Because what I'm really worried about here is we're stripping stuff out and the person who's in need of treatment doesn't get, it's not in the legislation.
Yeah.
Okay.
That's our goal too, is to get people transported who need
The need is there now.
threshold, and it's not something we take lightly or do
Right.
very often.
Okay, so go ahead.
That's sort of my feeling is like, what can we can't afford to miss between now and the end of the session? And that's sort of what I'm wondering.
I think from the DMH perspective, what we heard is that there were some concerns about the personal observation language maybe being a little too restrictive, but we also heard, and one of the foundations of everything DMH does is due process. So we need to assure the due process. So the language added does give a little more flexibility. It's saying there may be instances where you can't have personal observation, but in that case, the guarantee that assures the due safety is that someone is willing to sign an affidavit that they have personally observed it. So we're trying to find a balance. We're trying to make it easier to transport if it's really necessary, but also assuring the due process piece, which is, I think, where we heard concerns, right? Maybe some of that was missing. And so we're trying to compromise on the language, right? Give it a little more flexibility while also assuring due process. From DMH's perspective, that's what we're trying to do. We're trying to make it so that people can get the help when they need it as quickly as possible while assuring due process, because that needs to be a fundamental part of everything we do. If that's helpful.
And just from your own experience, Jack, from your experience, this piece about a person having to sign or do something under the penalty of perjury, is this going to interfere with somebody who's observed it and says, I'm not going to get into this, I'm not going to sign this? Before it was somebody that was there and they told the officer or the healthcare professional. Is this going to block that person from getting services that they need? In your opinions?
Well, in my opinion, and I see that Dylan's looking back to see who's in my opinion, this is really restoring the law to what we always thought it was and what it was intended to be. And I don't think it would create an undue delay. Part of the reason that the language that I came in with and included a statement under the penalty of perjury and not an affidavit is that we didn't want to have to require them to track down a notary to sign and have it be an affidavit. Anything that, and it's like many of the other documents that mental health professionals and psychiatrists sign in these mental health proceedings. It's simply a statement signed under the pains and penalties of perjury. And so, in my opinion, it would not, if the person's there and has observed dangerous behavior, then it should not create an unreasonable delay. If the person will not, is just refusing to sign, well, I don't think they can be forced. And that's the other side of it.
And I would say from my perspective, I also don't think so. I think it still leaves open the personal observation piece, which is from DMH's perspective what our expectation is. It may be helpful to clarify that DMH does get warrant applications, sometimes several in a week, that we refuse to file because we don't feel it meets the threshold. So there certainly are cases where we turn things down. What sometimes may be unclear to us is what the personal observation really looked like, or how that happened, because we're just reviewing the documents before we approve their filing. So this, I think, helps clarify what the DAs can and can't do to assure that when DMH is reviewing it, that we feel confident in what we're filing. But there's certainly, some examples we've heard we probably wouldn't file, right? There may be examples where it's really tenuous and we're not going to file that. But if it's on the fence, my advice to my client is to err on the side of caution and make sure we're holding up due process. And so I feel like this gives a little more flexibility and clarity to everyone. So it's real clear what people need to do. And this is all a balance, right? We always need to assure that people are getting the help they need, but we also need to assure due process. And so we're really just trying to strike a balance here.
Okay. How would this happen? I'm the person that saw what happened. What would I have to do? It says it supported by a statement of facts. What would I have to do to make sure that person got the treatment that I thought they needed and I thought that they were a danger in the present state? What would I have to do on site with that police officer standing there or a healthcare professional?
I will try to answer. My understanding is right now you would communicate that to the law enforcement officer and they would write it in the warrant application. And I think that you're asking, so with this, what would that look like? What does the form look like?
Yeah, because before I just said to you, the police officer, here's what I observed. Police officer wrote it down, put it in his report or her report. So that was it. Now, this is a bit different. As a matter of fact, it's a big difference. Okay, so tell me what I have to do.
Karen, can you answer that?
Yes, sir. I wasn't sure who you were asking. I frankly don't see it as a big difference. I think most of the warrants that we feel are good warrants, there already was some level of personal observation, right? It doesn't change the fact that if a QMHP has that personal knowledge, we don't need an additional statement. That personal observation is enough. If the police officer has that personal observation, that's enough. What we're hearing is there are some times where that doesn't happen. I think from our perspective, we thought that was probably fairly rare. It sounds like it may be more common than we thought. And so how do we balance that? So DMH has forms, right? And so I think it's just a matter of us amending our form. And so there could be a place where someone fills out their information and signs under the penalty of perjury. I don't think it will, they already have to fill out forms for us to review. I don't think it's going to be a large burden, but again, part of the idea behind having this be a trial was that we could come back if it's not working and say, hey, this is actually what we think needs to happen next year. That was the idea kind of behind the year, which again, I'm open to whatever, but that's what we were trying to do, is strike a balance.
And so what you're saying is now I would be signing something anyway. Is that what you're saying? Not just talking to I would be signing something. Right now.
If you were a QMHP or a law enforcement officer that was responding, you are signing something that you're submitting to us to review.
Okay.
The warrant application is written. Mm-hmm.
Okay, I'm not one of those. I'm a person.
We're talking about the narrow piece, Karen, where it is a person that needs to sign under penalty of perjury. Forget the QMHP and the law enforcement officer.
Yeah, so then I think so we haven't developed it yet, right? But I think we could just develop a form that people would have the paperwork with them when they're filling it out, and it could be a form that someone signs.
So right now, let me make sure we have this right. So right now, if Topper's the person, and that's the personal observation, the law enforcement officer or the mental health professional will talk to him, write down what he said, probably get his name and number, and that's it. This would add the piece of doing that, but then having Topper sign it under penalty of perjury.
But to clarify, we should not right now, under the way the language is written, not be filing something if there's not some level of personal observation. I
By
hear
whom? But
so if that's happening, right, then so I think we went back, right, and we're like, we need to look at this paperwork more closely. We need to make sure that we really understand when we're reading these, what we're reading. And so I think if we start taking a real deeper dive and really looking closely at the paperwork, because our intent never was to violate statute, right? But we're trying to give some flexibility to understand what the people in the field are telling us they need, right? And so that's what we're trying to do. We're not trying to make it more difficult. If the language stays as is right now, we're still going to have to take a much closer look at these documents to make sure that they're meeting it as written. And that may mean that we turn more down than we do now. The idea is that this language would give us the flexibility to be able to file some more if it is appropriate.
So my question is, what language are you talking about? I'm looking at a bill, and I'm looking at, I'm trying to understand what happens now without this bill. I don't sign anything under the penalty of perjury or anything else. I just say I relate what I saw happen.
But you shouldn't, but you shouldn't be the basis of that, right? Like it should be, what we're looking for when we're filing is that there's someone that has that real eyes on, that there is that personal observation, because that's the guarantee to DMH that the due process of the person is met. So law enforcement has seen this, or a QMHP has seen it. So I'll give you some instances where there's eyes on, right? So someone meets with the person, but the person isn't engaging. So you don't know anything other than what you're seeing. We take collateral information that's being provided, those two together create the probable cause, but there's still that eyes on piece. And that's the key, right? That's how it should be happening now, right? There should be some clinical or some law, someone should have eyes on. I think what we're hearing is sometimes that's not super practical. And so we're trying to also give them a path to move forward. But again, right now, there should already be those eyes on. It really shouldn't be that big of a change, right? I mean, the idea is that the statute has been in place for a long time. It does sound like maybe there's been some shifts as needed, and we're trying to adapt to those shifts, but also follow statute.
So we need to make sure, so there's some concern now that what is in statute is not what's happening in practice. And we need to make sure moving forward that it does. So whether it means we keep the statute as is and get practice to do it, or we change the statute in a way to make sure that everyone's constitutional rights are protected at the same time, everyone is doing practice matches the policy. That a basic where we are with this.
Than me. Explain.
Okay. So that's why I think it's really helpful for the people who know the statute and know the practice to try one more time to come together with language. And I'm going to say our legislative council is extremely busy. So Tuesday is probably going to be the earliest, but when she comes in, I'll make sure she knows to connect with all of you. All right, you had a question?
Well, I had it's for you, Lori, more than anyone else. We're going to have a committee discussion after this year. After we get done.
Right now we can.
We're in it now.
That's okay. That's
yeah, correct. That's what I mean.
If there's any more questions for witnesses.
Yeah, okay.
Okay. Thank you all very much. So we'll be connecting. Thank you. Thank you, Jack.
Thank you.
All right.
Okay. Being totally confused by this whole thing.
Yep.
It seems to me we ought to go back to the language we had, start with the bill that we had this morning. Add the piece in section 1 that they wanted to add, and add what Jack had onto it and go forward with the bill.
Right. I think that's what's going to come back to us, but I want there is some real disconnect right now between all of the advocates who want this. And so we need them to
Okay,
go and come back to us before we do all of that.
okay.
Yeah.
And it seemed like, it seemed your question about eyes on the situation, I think she was talking, our
Yeah.
Here.
testimony was talking about, the eyes of the police officer
Police officer or the.
Right.
versus what we want to try to do here.
Yeah, well, I'm not driving. I'm not taking the person anywhere.
correct, correct,
Right.
correct.
And I think that, I don't know if she understood.
Well, I just don't think that today, a personal observation means anything.
Well, I think what happened is through the testimony here and in judiciary,
Doing it that way.
there's a difference of opinion of what personal observation and the statute means. So there's statute and there's practice.
Practice, right.
And that's where I think there is some.
When you get into trouble.
So we want to make sure, again, that people's rights are protected, but we
Right.
also want to make sure that people can be helped as quickly as possible.
Yeah, right,
And so I think there's a little, it's a balancing act. So
right.
And it sounded like they were also trying to get another avenue forward, but sometimes someone else is observing it. How do you make a mechanism that may allow that without infringing on someone's rights?
Right, exactly.
Because I thought we had a pretty good bill here. I mean, I
Yeah.
thought it was good, and then I saw this, I said,
Right.
what the heck are we doing?
So let's
Yeah.
pause.
Yep.
And you know what?
Yes.
Honestly, if this doesn't get out, it doesn't get out, right?
Yep.
So
Yep.
we'll do the best we can to find a path forward.
But that's what worries me, if I may, because that's why I said what we can't afford to miss between now and a year from now, or whenever it is that we get it out. And that's what I want to protect. If there's something that needs to get out,
We'll do our best.
Tuesday, then I would love to protect who needs to be protected between now and then.
Yeah, the other thing too is if we're on a path to get it out by Tuesday, then we'll do it ourselves and get it out.
Right.
We've got enough information here to,
Yeah, yeah.
All right,
because I was all set with the other bill.
me too. And that was so now.
Is that a general consensus?
Yes, I.
Yes, and I feel strongly that, when the provider coalition brings something forward, that represents a lot of people.
Sure.
And our providers are people that, they don't have a broad platform or a lot of time or money to, advocate for themselves. And so I understand that DMH is trying to align this with a process and have a protocol for it, and appreciate all of that, of course. But I think it's incredibly important to support providers that want to be sure that, what they're doing in the field to get people to care is supported. So I think this is a priority.
And I feel.
And I just want to be clear, I'm not saying it isn't a priority. I am understanding we have 2 weeks left in this session.
Yeah.
And I must say that I feel similarly, and especially now, I feel it's strengthened by having the warrant at a time, and I think that really seemed to strengthen it. And then also that there are ways for people, like what was just shared by Jack, is maybe not having to have it be a signed affidavit, because it seemed like that was something that was really maybe onerous on people, and also didn't provide any opportunity for people that may be in a dangerous position not to have their statement public. So I felt like there were some definite improvements that came out of the process, and seemed like we're moving in the right direction.
Okay, so let me ask this, and then I promise we'll take a break. If we go back to the original bill, right, which clarifies temporary custody is under the law enforcement officer, and we add in the 72 hours, and we add in the personal observation piece, and we do the additional study, because I do think there's so much unclearness, is that a word, here, that I think that report is important. Do you want to change all of those things for a year? Or do you want to make it permanent unless the report comes back and then we change it?
Make them permanent unless.
Once they come back after looking at it.
No sunset.
It would seem that the bill itself is the study. Why do a study?
Well, it's not a study, it's a report back on the, right. And
How it's going.
I think it's really important, because I think what this process has determined is that
Yeah.
There's a lot of difference between policy and practice. So I'm sorry, can I have Karen and Jack back on? So I don't know if you were paying attention to that conversation. So do you have any comments? If we go to Katie and say, we want the temporary custody to be specific to the law enforcement officer. We want the language just proposed to us on the personal observation. We want the 72 hours. It would be permanent, but we're going to get the report back, understanding that if it's not working, we want to change it. What are everyone's thoughts on that? Jack?
I think that would work for us.
Dylan?
That would work. I would just add the one other piece, which was around the judge can order the law enforcement only to transport and the clinician transports if clinically.
If clinically appropriate, yes, that was the language. Karen, can you comment or do you want to get back to us?
Yeah, I think that's fine. I think the part that we really want to have some clarity around is the personal observation.
Okay. Okay.
Then they can have when they make their report, they can tell us how that's
Right.
working.
You're right.
Great. Okay, so I'm going to suggest all of this to Katie, and I will get this back on the schedule for Tuesday with a possible vote. Is everyone comfortable with that?
Yeah.
Great.